one and all, distinguished guests, esteemed delegates, judges of Honorable Supreme Court, High Court, District Judiciary, both past and present, arbitrators, senior advocates, members of the bar, students of law, welcome to all. It's my honor and privilege to welcome you this evening to this inaugural ceremony of the first edition of Bengaluru ADR Week on behalf of myself and the organizing committee of Bengaluru ADR Week and all the institutions which are supporting this event. When we conceived the idea of Bengaluru ADR Week, we could not have imagined the kind of enthusiasm, participation and support that we would receive from High Court of Karnataka, Arbitration and Conciliation Center, Bangalore, Karnataka Judicial Academy, the Advocates Association, Bangalore, and most importantly, the overwhelming response that we received from the members of Karnataka Bar. Months of hard work and preparation have culminated in this coming together of the bar and the bench to discuss and deliberate the nuances of alternate methods of dispute resolution, making Bangalore a preferred place for resolution of disputes and making our state the preferred seat for arbitration. I would like to welcome onto the dais our esteemed guests for the evening. I request the members of the organizing committee to usher the guests onto the dais. Honorable Srimati Justice B.V. Ragaratna, Judge, Supreme Court of India. Honorable Justice Arvind Kumar, Judge, Supreme Court of India. Honorable Justice N.V. Anjaria, Chief Justice, High Court of Karnataka. Honorable Srimati Justice Anu Sivaraman, Judge, High Court of Karnataka and President, Karnataka Judicial Academy. Honorable Srimati Justice K.S. Mudgal, Judge, High Court of Karnataka and President, Arbitration and Conciliation Center, Bangalore. Shri Arvind Kamath, Additional Solicitor General of India, High Court of Karnataka. Shri Shashikiran Shetty, Advocate General for the State of Karnataka. Mr. Vivek Reddy will join us. I welcome him. Mr. Vivek Subbareddy, President, Advocates Association, Bangalore. I request all the dignitaries on the dais and all present in the auditorium to rise for the Nadagite.
जननीय तनुजाते जय हे कर्नाटक माते जय सुंदर नदी वनಗಳ ನಾಡೆ जय हे रस ಋಷಿಗಳ ತೀರೆ ಭೂದೇವಿಯ ಮಕುಟದ ನವಮಣಿಯೇ ಗಂಧದ ಚಂದದ ಹೊನ್ನಿನ ಗಣಿಯೇ ರಾಘವ ಮಧುಸೂದನರವತರಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ ಜನನಿಗೆ ಜೀವವು ನಿನ್ನಾವೇಶ ಹಸುವಿನ ಕಿವಿಗಳ ಸಾಲೆ ನಿನ್ನಯ ಕೊರಳಿನ ಮಾಲೆ ಕಪಿಲ ಪತಂಜಲ ಗೌತಮ ಜಿನನುತ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಶಂಕರ ರಮನುಜ ವಿದ್ಯಾರಣ್ಯ ಬಸವೇಶ್ವರ ಮಧ್ವರ ದಿವ್ಯಾರಣ್ಯ ಕಣ್ಣ ಷಡಕ್ಷರಿ ಹೊನ್ನ ಸಂಪಲ ಕುಮಿಪತಿ ಜನ್ನ ಕುಮಾರ ವ್ಯಾಸರ ಮಂಗಳ ಕನ್ನಡ ತಾಯಿಯ ಮಂಗಳ ದೇಹ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ ಜಯ ಹೇ ಕರ್ನಾಟಕ ಮಾತೆ.
Thank you. Now, may I call upon Srimati Justice K.S. Musgal to
Honorable Justice Srimati Justice B.V. Nagratna, Judge Supreme Court of India. Honorable Shri Justice Arvind Kumar, Judge Supreme Court of India. Honorable Shri Justice N.V. Anjaria, Chief Justice High Court of Karnataka. Honorable Srimati Justice Anu Shivaraman, Judge High Court of Karnataka and President Karnataka Judicial Academy. Shri Arvind Kamath, Additional Solicitor General of India, High Court of Karnataka. Shri K. Shashikaran Shetty, Advocate General for State of Karnataka. Shri Vivek Subbareddy, who is arriving soon, President Advocates Association, Bengaluru. My sister and brother judges of Honorable High Court of Karnataka, respected former judges of the Honorable Supreme Court of India and High Court of Karnataka, esteemed chairpersons, speakers of business sessions and judicial officers, the delegates of Bengaluru ADR Week, other dignitaries, ladies and gentlemen. As the President of Arbitration and Conciliation Center, Bengaluru, I deem it a great privilege to extend a warm welcome to one and all. On 22nd November 2012, the Arbitration and Conciliation Center was established at Khanija Bhavana as a unique initiative of High Court of Karnataka with a motto of providing affordable and speedy justice through ADR mechanism to public at large. From the date of its inception, there has been gradual increase in the cases received at center. The data would disclose that only 28 cases were filed in the year 2013. After COVID-19 pandemic, every year 700 plus cases are being filed in the center. This year, by this time, the said number has reached more than 1,100. In order to flourish an improvised system of arbitration in the state of Karnataka, mere increase in the number of arbitration cases is not sufficient. There should be improved professionalism on the part of all the stakeholders in resolution of disputes by arbitration. We are all aware that India has emerged as the fifth largest economy of the world. Needless to say that despite all good resources and infrastructure, if commercial disputes are dragged for decades together without resolution, investors hesitate to invest in such countries. To march further in economical development, qualitative and speedy resolution of domestic and international commercial disputes is imperative. We at the Arbitration and Conciliation Center notice that there is no mechanism where all stakeholders involved in the arbitral process could assemble together and have a meaningful deliberations. Some senior counsel and other members of the bar expressed with us their keenness to take steps in this direction. Thus, for the first time ever in Karnataka, we conceptualized this unique event, Bengaluru ADR Week 2024, in association with Karnataka Judicial Academy, Advocates Association Bengaluru, and Bengaluru ADR Week Committee. During preliminary meetings, someone asked me as to why this program. For that, I am reminded of a story. I take a little time for this. Once Lord Indra, the god of rains, grew angry with the farmers and cursed them that he will not shower rains for 12 long years. Fearing that everything on planet Earth reaching a grinding halt without water, panicked farmers pleaded with him to withdraw his curse. Indra suggested that if Lord Shiva plays his Damaru, the curse would be redeemed. So the farmers approached Lord Shiva with a request to play his Damaru. Lord Shiva said that until Indra asks him for that, he will not play. Saying so, he hanged his Damaru to a nearby pole. In the process, some time passed and the drought set in. The farmers, losing their hopes of rain, abandoned all agricultural operations. When the things stood thus, one farmer, without being disturbed, continued to plough the land, sow the seeds, and his other agricultural activities, though there were no rains or returns. Other farmers were wondering why he was doing such futile exercise and asked him the purpose. The farmer told them that for 12 long years, if he does not perform his given activities, by 13th year, himself, his cattle, land, including the whole earth would forget or lose their skills and efficacy, making it impossible to resume the cultivation when it rains. To avoid that, he said he is carrying on operations unmindful of not getting the rain. This conversation was heard by goddess Gauri. She grew anxious that by not playing Damaru for 12 years, Lord Shiva may also forget the skill of playing Damaru. She rushed to Lord Shiva and expressed her concern. Soon Lord Shiva, to check whether he has forgotten playing Damaru, pulled that from the pole and played the same. The Damaru sound enveloped the universe. Hearing that, Lord Indra had to shower rains. The analogy from the story is, these kinds of programs are needed to check whether we have forgotten our efficacy, to refresh skills and sharpen our sword of knowledge. Some senior advocate had asked me this question, so I am reminded of this story. Further, the motto of organizing this ADR Week 2024 is to enrich knowledge of all stakeholders on the subject, coupled with catering to the needs of litigants to get speedy justice. With this novel idea in mind, we have meticulously devised business sessions and have invited eminent jurists and legal luminaries in the field to have better interaction and deliberation. Perhaps through this event, we propose to draw an action plan for enhancing the quality of arbitration. Hence, we have adopted the meaningful theme, expanding the horizon, marching towards world-class arbitral institutions. Arbitration is prevalent in India right from the Vedic era. One of the earliest known treatises that mentions about arbitration is Brihadaranyaka Upanishad. Rishi Yagnavalkya has referred to some arbitration bodies like Shreni, means business communities, Puga, local courts, and Kula, wise men of community, and they were known as Panchayat. Many disputes were referred to a small group of wise men of community known as Panchayat, wherein the senior most person was named as Sarpanch. Members were known as Panchas, and the decision taken by them were binding on the parties. So, earlier the disputes were solved in our country through Panchayat Nyaya system. The disputes which were referred to Panchayats were well recognized, and the awards passed by them had great significance. The Privy Council, in the case of Vaitla Seethanna versus Marivada Veeranna, reported in AR 1934 Privy Council page 105, recognized them. They can be regarded as one of the earliest forms of arbitration in India. Therefore, in my opinion, attempts at creating a proto-ADR mechanism, including arbitration, is something Indians can take pride as part of our legal culture. At the first codified arbitration law in India was Bengal Regulation of 1772 during the British rule. Thereafter, Arbitration Act 1940 was enacted, which brought uniformity in law across the nation. At present, we are governed by more refined Arbitration and Conciliation Act 1996, which was adopted by the UNCITRAL model of United Nations. Due to its utility and efficiency, arbitration has become the most preferred mode of ADR mechanism. Through this event, we propose to achieve the theme of Bengaluru ADR Week. To inaugurate this program, we have amongst us today Honorable Srimati Justice B.V. Nagaratna, Judge Supreme Court of India. Her leadership is known for her firm decisions, humility, work ethics, and fostering of ADR values to settle the dispute between the parties. When we requested her ladyship to inaugurate this program, she not only wholeheartedly accepted our invitation, but also gave us valuable insights in the matter. We are honored by gracious presence of her ladyship in today's inaugural function. I am sure the vision of Honorable Srimati Justice B.V. Nagaratna will propel the required action plan for improving the arbitration setup in the state of Karnataka. On behalf of all the organizers and on my own behalf, I extend a wholehearted welcome to your ladyship. I request the Honorable Justice Commissioner Rao to extend floral welcome to Madam on behalf of all of us. His Lordship, despite his busy schedule, was kind enough to accept our invitation and has graced the occasion. His Lordship was instrumental in the development of Arbitration Center at Bengaluru as a member of the Board of Governors from 1/3/2012 to 31/5/2018. All of us are looking forward to your Lordship's valuable guidance on this momentous occasion. On behalf of Arbitration and Conciliation Center and all the organizers and on my own behalf, I extend a respectful welcome to you, sir. I request Honorable Justice K. Somshekhar to extend a floral welcome to his Lordship. Honorable Shri Justice, Chief of Arbitration Center, is with us today as the President of this inaugural function. For this program, his presence means much as he comes from the land of Lord Krishna and Mahatma Gandhiji, who greatly watched for resolution of disputes through arbitration. We are beholden to the constant support and motivation extended by his Lordship in organizing this event. On behalf of all the organizers and on my own behalf, I extend a respectful welcome to you, sir. I request Honorable Mr. Justice Mohan Court of Karnataka and President Karnataka Judicial Academy also hails from the land of Guruvayur Krishna. You all may be knowing that meaning of the word Krishna is one who attracts. Without fear of any contradiction, I state that carrying the magnetism of Krishna, on her arrival here, she has won the hearts of all. She and her team are the pillar of support in organizing this program in this beautiful venue. On behalf of all the organizers and on my own behalf, I extend an affectionate welcome to you, sister. I request Srimati Justice L.G. Uma to amongst us today, Shri Arvind Kamath, Additional Solicitor General of India, High Court of Karnataka, and Shri Shashi Kiran Shetty, Advocate General for the State of Karnataka. They have been highly supportive in planning the event. On behalf of all the organizers and on my own behalf, I extend an affectionate welcome to both of you. I request Pradeep Nayak to extend floral welcome to you. Of learned members of the bar. As a representative of Advocates of Bengaluru, we have with us Shri Vivek Subbareddy, President, Advocates Association, Bengaluru. The entire advocate fraternity has been steering the wheels with us for effective organization of this program. On behalf of all the organizers and on my own behalf, I extend warm welcome to Shri Vivek Subbareddy and request Shri Advocate Pradeep Nayak to present a bouquet to him. Justice Mohammad Nawaz, Justice E.S. Indiresh, Justice M.G. Uma, Justice C.M. Unacha, the Board of Governors of Arbitration and Conciliation Center of High Court of Karnataka have been a great team in devising the nitty-gritties of this program. The support of Justice K. Somshekhar, Justice Srinivas Harish Kumar, Justice S. Sunil Dutt Yadav and Justice S.R. Krishna Kumar the Board of Governors of Karnataka Judicial Academy in organizing this program is immeasurable. On behalf of all the organizers and on my own behalf, I extend most affectionate welcome to you all. I extend a warm welcome to all my sister and brother judges of High Court of Karnataka who have responded to our invitation and made it convenient to attend the inaugural program. With great reverence, we all the organizers acknowledge the gracious presence of respected former Supreme Court judges of India, Justice Ravindran particularly, and former judges of High Court of Karnataka. On behalf of all the organizers and on my own behalf, I extend you, my lords, a respectful welcome. To achieve the goal of this event by meaningful deliberations, we have elite resource persons. I extend a heartfelt welcome to esteemed chairpersons and speakers of the business sessions. I am sure their immense knowledge and experience in the field will help us to come up with concrete recommendations and an excellent action plan for strengthening the arbitration process in the state of Karnataka. I also extend warm welcome to Shri Bharat Kumar, Registrar General, High Court of Karnataka, and all the judicial officers of the registry. I extend warm welcome to Shri Dinesh Hegde, Director Arbitration Center, and Shri N.P. Marathe, Director Karnataka Judicial Academy, and their team of officers who have been working relentlessly for this program. I extend affectionate welcome to all the judicial officers who are attending this program. I extend respectful welcome to senior advocates, members of the bar, and delegates to this program. I hope that there will be better deliberations and interactions. I extend warm welcome to the staff of Karnataka Judicial Academy, Arbitration and Conciliation Center, and High Court of Karnataka. I extend warm welcome to press and media. I extend warm welcome to all those who directly and indirectly helped us in organizing this program and who are attending the program through virtual mode. Let me conclude with a verse in Rigveda, Om Sangachatvam Samvadvam, means let us sit together, discuss together, share with each other, so that information is assimilated and disseminated for the benefit of all humanity. Thank you one and all. Jai Hind, Jai Karnataka.
Mentioned the theme of the ADR week and the need to have such events. May the Damaru of your initiative resonate far and wide, and let the Damaru be played every year would be our wish. I request Justice C.M. Ponacha, Judge High Court of Karnataka and Member Board of Governors of Arbitration and Conciliation Center, Bengaluru, to kindly present okay to Justice Mughal. I would request the dignitaries on the dais to kindly light the lamp to mark the beginning of the first edition of Bangalore ADR Week.
Dipajyotirnamostute
Justice Mudgil to offer a floral bouquet to Justice Ravindran, who was present in that. I would now request Mr. Vivek Subbareddy, President, Advocates Association, Bangalore, to say a few words.
Honorable Judge of Supreme Court Justice Nagaratna, who is always the friend of the bar and caring for Karnataka, and another long-term friend of the bar who will never break his bonds with our association, Justice Arvind Kumar. I am really happy to be part of this event presided by two senior judges of the Supreme Court. And we always will never forget an immemorable figure, Justice Ravindran, of the former Supreme Court judge. Justice Anjaria, our Chief Justice, and it takes pride because just about 3 or 4 days ago, the Karnataka High Court unraveled the earliest cause list in India, published at 5 p.m. or 5 p.m. thanks to our Chief Justice's initiative, which is a phenomenal achievement. Honorable Justice Anu Shivaraman, who has made Karnataka our home and who has become part of us. So much part of us that we do not think she is from Kerala at all. Honorable Justice Mudgal, who has taken so much pains for this event, organizing it every step and making it a success. The Honorable Advocate General of Karnataka, who is still to give us a mediation center recommended from the government, and which I am sure that he will get it done shortly. Honorable Additional Solicitor General, ever humble, Shri Arvind Kamath. Friends, when we attend such functions, I think it is only in such rare occasions we find a unique blend of former judges and present judges. It's like an alumni of judges. And this is by far the only rare event where judges outnumber the lawyers. And the power of the lordships is, former and present lordships, is omniscient. And we see it very rarely. And it's a unique collection or a galaxy of judges coming together in a convocation. The Advocates Association will always cooperate in this endeavor. I'm here to say that whatever be the circumstances, we will always favor the Alternative Dispute Resolution Forum. And members of the bar have been actively participating, both under the 1996 enactment and under the 1940 enactment. And in recent years, particularly India today emerging as a world economic powerhouse, I think that we see that there is a flood of litigation, and even 50 judges of High Court are not enough. We need more judges. We need more justice forums. We need more quality justice redressal forums. And arbitration is one such forum. Retired judges of our high courts pass amazing judgments as arbitrators. And we find that those judgments usually pass the test of appeals. There is one paradox, that when an arbitrator passes a judgment, there is very limited scope to modify it in appeals. And that also is a factor that has to be taken into that has to be assessed by proper legislation, so that there is a logical end to these arbitral proceedings. So the request of the bar, the first Damaru request of the bar is that we need a state-of-the-art arbitration center like in Hyderabad. The Honorable Advocate General should take the lead in getting us 100 acres, probably near the international airport at least, so that we can have a wonderful arbitration center. And we also thank Honorable Justice Arvind Kumar and Justice Nagaratna. Madam. It is allotted and it is in the process of getting. We thank Justice Nagaratna Madam and Justice Arvind Kumar for giving 3 very good souls, number 1, 2, 3, for our High Court. And really, we appreciate the manner, the temperament, and the way the first 3 judges are looking after the courts. We have a second Damaru request, and only Justice Nagaratna and Justice Arvind Kumar can arbiter it with the Chief Justice of India. So you are our arbitrators. Please give us a Chief Justice of Karnataka, at least 3 Chief Justices of Karnataka. With that request, I end my short speech. Thanking you very much. The bar will cooperate in all the assignments towards alternative dispute resolution forum. Thank you very much.
And I think Mr. Shashikaran Shetty has now multiple tasks as per the request of the bar. I now request Mr. Shashikaran Shetty, Advocate General, State of Karnataka, to address the gathering.
B.V. Nagaratna, Honorable Justice Arvind Kumar, we are deeply honored to the distinguished judges of the Supreme Court for gracing the occasion despite the demanding schedule. Their continued support and commitment to elevating the standards of legal practice in Karnataka is eminent from the frequent participation of the events in Bangalore or in particular Karnataka. We have here Justice Ravindran, Honorable former Supreme Court Judge, whom we can say Bhishma Pitama of arbitration in Karnataka. Honorable Chief Justice in Anjaria. Today marks exactly 6 months when Honorable Chief Justice took charge in Karnataka, who is also a trained mediator and he is invested in promoting and optimizing ADR revenue for disputes. As Mr. Vivek Reddy said, Justice Anu Shivaraman has won the hearts of all the lawyers in the High Court, and Honorable Justice K.S. Mudgal has put in extremely hard work to make this ADR week a success. She has taken it personally, taken each and every detail to its logical end. As usual, my friend Vivek Reddy, whenever he takes a mic, he makes a demand. Irrespective, it's become a usual practice. No, I don't think anybody will take him seriously. And being the president of Advocates Association, he thinks everybody else has to do his work. And Arvind Kamath, my good friend, all the people on the dais, honorable judges sitting and retired. And also I'd like to congratulate the members of the Karnataka Judicial Academy, Advocates Association, member of the Arbitration and Conciliation Center, members of the ADR Week Committee who have toiled to bring this event to life, young lawyers, staff and media persons. In fact, all the stakeholders are present here today. This event is remarkable in many ways, especially due to its participation. We have representation from all stakeholders, namely judges from the highest court to the lower court, Judicial Academy, Advocates Association, students, policymakers, and media community, all gathered here to support this initiative. This event marks an excellent start. ADR has gained prominence for its significant benefit in the age of tremendously growing disputes. Among other benefits, I see ADR as a means to elevate Karnataka's status on the global stage and to also significantly boost our economic prospects. This vision can be materialized if we are able to optimize the opportunity around us and transform Karnataka into a leading global arbitration hub. The evolution of India's arbitration landscape has been significantly shaped by judicial interpretation as well. There has been many consistent evolution of judicial precedent aimed at minimizing judicial intervention, expanding the scope of arbitrability, promoting the enforcement of foreign awards, increasing the importance of arbitrator neutrality and independence. To position Karnataka as a global arbitration hub, we can learn from international best practices. We can learn from the experiences of places like Singapore, Hong Kong, and London. Singapore arbitration dominance was accelerated by strong government support, a pro-arbitration legal framework, minimum court interference, and an open regime for international lawyers. Hong Kong, another leading arbitration hub, offers different but equally valuable lessons as a standout feature of Hong Kong system. It is specialized arbitration courts, arbitration-related applications are dealt by judges with expertise in the field, leading to more consistent and arbitration-friendly decisions. To further the growth of Karnataka to become a leading arbitration hub, there are certain aspects we have to focus on. Invest and develop in world-class arbitral institution that can compete with global centers like Singapore, Hong Kong, and as Vivek said, Hyderabad has taken a leap in this direction. Review and bring about necessary changes to the present policy on arbitration and the existing rules. Adapting technology in arbitration can significantly enhance the efficiency, fairness, accessibility. Good technology infrastructure also allows for better case management, efficient hearing without delays, easy arbitration between cross-border entities, provide flexibility in structuring the proceedings. We must aim to establish state-of-the-art technological infrastructure, foster collaboration with international center and ADR community through MOU and other means, draw attention to the capabilities on global scale to make our presence known and felt. This can be through sending delegations to business gathering, ADR conferences, showcasing our arbitration capability during the upcoming global investor meet. In fact, ease of doing business. In fact, arbitration, for example, if you are able to retain the kind of companies that are in Karnataka, having arbitration clause, the place of arbitration of Bangalore itself is a big beginning. In fact, most of the kind of companies, either IT, pharmaceutical, biotechnology, most of what I've given to understand don't make Bangalore as a place of arbitration. First, we need to retain the industries which are in Bangalore to make them and market. In fact, we need to market it to show that Karnataka or Bangalore is a place of arbitration. Creating arbitration-friendly ecosystem is very important. Promoting awareness among the arbitration institutions, including conducting extensive outreach programs for businesses and lawyers. Further encouragement from the public sector undertaking to adopt institutional arbitration clauses. We must focus and empower our arbitral institution to introduce expedite procedure. Karnataka is uniquely positioned to become a global arbitration hub. We have talent, infrastructure, and business ecosystem. We now need is a focused effort to develop. In fact, what I would suggest is we have just a 9,000 square feet of immediate in Kanija Bhavan. We need to expand it at least to 30,000 square feet in and around in the existing building itself, provide infrastructure which is required over there. Let me see, as Vivek said, in fact, there's KADB Industries Department is right adjacent to the arbitration center. If possible, request them to shift somewhere else so that we'll have one or two floors of 25,000 square feet, so that will be the beginning. Let me see what best I can do and things like that. From my side, I'll try my best. Thank you. Thank you for this opportunity.
Advocate General Shashikiran Shetty for the assurance of providing better infrastructure facility for the arbitration center. I think it's not just the request of Vivek Reddy alone, the entire bar has been requesting for better infrastructure. And I'm sure this will also form part of the resolution that's going to be drawn up at the end of these deliberations. May I now request Shri Arvind Kamath, Additional Solicitor General, to address the gathering.
This is Arvind Kumar, Honorable Chief Justice, all the other dignitaries on the dais, Justice Ravindran, who has literally shaped the arbitration law under the 1996 Act in the first 2 decades, and all other dignitaries of the dais. Good evening, everyone. A robust economy needs a very robust dispute resolution system. Undoubtedly, India is now a robust economy. The question is, have we given back an equally robust dispute resolution system? The 1996 enactment of the Arbitration and Conciliation Act was expected to provide a dispute resolution system which is alternative to the conventional judicial system. It was expected to achieve at least 3 tasks. Number 1, to reduce the burden on the judicial system. Number 2, to provide a cost-effective judicial dispute resolution mechanism. And number 3, to provide a quick and efficient means of dispute resolution. Now, the experience in the last nearly 3 decades has shown that on all 3 fronts there are challenges galore. We may have unburdened the trial courts with the civil suits, but we have burdened them with applications under Section 9 and 34. We may have taken away the RFAs from the high courts, but we have brought back the commercial appeals and the miscellaneous appeals. The litigant may have been spared from the weight of very high ad valorem court fees, but then we have saddled him with huge arbitration costs. And lastly, even on a comparative basis, if arbitration is much quicker, on the parameter of efficiency, there are as many number of questions as the answers. But having said that, despite all these hurdles, arbitration, particularly the institutional arbitration, still holds a lot of promise and hope for arbitration, for dispute resolution in India. In fact, the institutional arbitration is here to stay, and there is no looking back. The performance and the enormous success of our arbitration center here in Bangalore is a tall testimony of that fact. There is a game-changing event that is due to take place, hopefully in the near future. That is the implementation of Part 1A of the Arbitration and Conciliation Act, by which sections 43A to 43M were introduced. That creates the Arbitration Council of India. Now, the primary duty of the Arbitration Council of India would be to promote and encourage arbitration in India, to frame policies, to grade institutions. And once that takes place, we have a professional body which will monitor the growth of arbitration in India, which will guide it. And this professional body will definitely help us in tying the loose ends and filling the gaps, which is currently, which is missing as of now. But till that time, to nurture the arbitration is the responsibility of the stakeholders. We, the stakeholders, that is the lawyers, the arbitrators, and the courts, have the onerous responsibility of nurturing the arbitration. Now, how do we do that? We have to identify the challenges in the working of the arbitration law. We have to deliberate, debate, and find solutions. Because once the arbitration council starts functioning, then the entire arbitration ecosystem in India is going to change radically and positively. So, therefore, ladies and gentlemen, the road ahead that lies ahead is one of hope and promise. Till then, it is the responsibility of the stakeholders. And in this direction, events like the Bengaluru ADR Week plays a very stellar role. The efforts made by the Arbitration Center, spearheaded by Honorable Justice Mudgal, is highly commendable. very, very ably supported by the organizing committee. Hearty congratulations to the organizers for organizing such a wonderful event where eminent judges, jurists, and lawyers come together and deliberate and debate on various aspects that is throwing a challenge to the arbitration in India. I think if we resolve and make the domestic arbitration culture stronger, then making it international is quite easy. So in this direction, the current ADR week is going to play a major role. So with this congratulatory note, I thank the organizers for giving this opportunity to share some of my thoughts. Thank you.
Arbitration process and the hurdles which we are facing in the process. And I'm sure these are issues which are going to be discussed and deliberated upon in the next 2 days. You've highlighted the need for institutionalization. I'm sure that is going to happen in the near future. Thank you very much. May I now invite Srimati Justice Anu Shivaraman, Judge, High Court of Karnataka and President of Karnataka Judicial Academy, to deliver this evening's special address.
Judge, Supreme Court of India, Honorable Shri Justice Arvind Kumar, Judge, Supreme Court of India, Honorable Justice N.V. Anjaria, Chief Justice, High Court of Karnataka, Justice Ravindran, my sister Srimati K.S. Mudgal, and other governors of the Arbitration and Conciliation Center, Bengaluru, all my esteemed sister and brother judges present here, past judges, Registrar General, other registrars and officers of the High Court, Director, Additional Director, and all other officers of the Karnataka Judicial Academy, Director and other officers of the Arbitration and Conciliation Center, Bengaluru, Shri Arvind Kamath, Additional Solicitor General of India, High Court of Karnataka, Shri K. Shashikiran Shetty, Advocate General, Karnataka, Shri Vivek Subbareddy, President, Advocates Association, Bengaluru, Shri Harish Narsappa, Senior Advocate, and all other senior advocates and advocates involved with the organization of this prestigious event, esteemed chairpersons and speakers of the business sessions, delegates, dignitaries of the dais, and this esteemed audience. Ladies and gentlemen, Ellarigu Shubha Sanjay. The very fact that I am here before you delivering this special address is indicative of the warmth and inclusiveness which is characteristic of the bench and the bar of this state. It is my privilege to be a participant in this prestigious occasion where the bar and the bench come together to examine the strides made in alternate dispute resolution with specific emphasis on arbitration and to chart out the roadmap for the future. An elaborate special address in a function graced by so many illustrious figures may be a little out of place. Therefore, I'll present a short synopsis of the few key points which I would like to place for the consideration of this august gathering. When we speak of alternate dispute redressal, we need to examine what is the essential function of the courts of law. It is indeed the resolution of disputes which form this core function. Therefore, alternate dispute redressal mechanisms like arbitration are obviously carrying out the functions of the courts of law in areas that the formal judicial system is unable to deliver speedy justice due to its inherent limitations, primary among them being the sheer disparity of numbers. Therefore, very obviously, arbitration as a mechanism for resolution of disputes cannot be completely divorced from the basic principles of dispute resolution, which are the life breath of the legal system. While accepting so, we must, however, make a real attempt at assessing where we really stand with regard to the acceptance of the alternative methods to speed up the process of resolution of disputes. The assessment must be honest and realistic, and we must accept shortcomings where we find them and course correct wherever required. The assessment and course correction is crucial to the continued success of alternate dispute redressal. What we must also bear in mind is that for any system of dispute resolution to be successful, the credibility of the system is of prime importance. For a person who enters into an agreement to seriously consider making arbitration as a method of choice in the event of a dispute arising, the entire system has to be demonstrably effective, fair, and efficient. Sans this credibility, the mechanism cannot earn the trust of the most important stakeholders, the potential users. It is towards creating and protecting this credibility that all of us must work in tandem. The arbitrations conducted by some finance companies and the in-house arbitrations of statutory corporations are some illustrations of the problems we have faced pre the 2015 amendment. I do not intend to make any comment on the impartiality of the in-house arbitrators. They were, as a matter of fact, scrupulously impartial on occasion and returned impeccable awards. But as a process, the existence of a relationship or interest would tend to undermine the independence and impartiality and thus the perceptions of credibility of the mechanism of arbitration. When arbitration is resorted to between equals, as between contracting parties like corporations, commercial entities, etc., it is highly effective and credible. But when the contracting parties are clearly unequals in terms of finance, resources, and power, then the issues of credibility arise. The arbitrator, as we all know, cannot rely on the principles of equity to even out disparities. Such situations can also create unfavorable impressions and perceptions, which can affect the overall credibility of the system. This is obviously the reason why unequal relationships must remain out of the realm of arbitration. That they remain out is essential for the system to remain viable. It is through serious and realistic discussions and consultations like the present one that the mechanism of arbitration will be made capable of addressing the issues and progressing on in an effort to meet the need of the hour. I congratulate the organizers of this event for the efforts taken to hold this consultation and wish them all success in their future endeavors. Thank you very much. Jai Hind, Jai Karnataka.
Insightful words and highlighting the need for the system to gain credibility and the need to protect credibility of the institution and the need for impartiality to be imbibed into the process of arbitration. Now, may I call upon our Honorable Chief Justice, Justice N.K. Anjaria, to deliver the presidential address.
Honorable Ladyship, Srimati Justice B.V. Nagaratna, Judge Supreme Court of India. My Lord Honorable Sri Justice Arvind Kumar, Judge Supreme Court of India. Respected Justice Ravindran, former Judge Supreme Court of India. Sister Srimati Justice Anu Sivaraman, Sister Justice K.S. Mudgal, Sister and brother judges of the High Court of Karnataka gracing the occasion, in the audience, Sri Arvind Kamath, Sri K. Shashikaran Shetty, officers, Registrar General, senior advocates, advocates' friends, judicial officers, and everybody present in the audience. This evening we inaugurate the Bengaluru Alternative Dispute Resolution Week 2024. It is a matter of great pleasure that two honorable judges of the Supreme Court of India, who are indispensable part of the judicial family of Karnataka and who associate without fail in all significant occasions of the institution, are again amongst us. I welcome both of them Justice Nagaratna was telling me, I don't know whether I belong to Delhi or Bangalore. I would say that the Delhi may have stake and claim over Justice Ragnatna, but the Karnataka has a secured claim and first charge. So is the valuable presence of Justice Arvind Kumar. I am privileged to speak on this occasion. This significant event is initiated by the Bengaluru ADRV committee and now organized with Association of Arbitration and Conciliation Center Bengaluru along with Karnataka State Judicial Academy. It symbolizes our collective commitment for promoting the arbitration as alternative dispute resolution mechanism to be available to all class of litigants in national and international legal field. I just pause here. I forgot to mention in my address Vivek Reddy. Advocate General said that nobody takes him seriously. But as far as I am concerned, I have no option but to take him seriously in respect of all his demand. So pardon, Mr. Vivek Reddy, that I forgot your name. Now the theme of ADR week is expanding the horizon, marching towards world-class arbitral institutions. It is an instructive theme which indicates that we should align ourselves towards building a dispute resolution framework which not only meets but exceeds the global standards. The ADR has roots in Indian history and ancient times. The old practices of panchayat and the group of wise men of the community resolving the disputes have found relevance now in the process of alternative dispute resolution mechanisms, which includes the process of arbitration. Indian legal system has adopted more than one methods of alternative dispute resolution. The arbitration on the lines and to further the objects of the Arbitration and Conciliation Act 1996 is one such important mechanism. The process having gained worldwide importance, the need of the time is to modernize the Indian arbitration law processes and the institutional framework in the country. The intake of global needs and practices in the arbitration will accelerate the process of making India a global arbitration hub. If I divert a bit, all of you must be knowing, and I say with pride that High Court of Karnataka has got the arbitration center which possesses the standard infrastructure capable to facilitate the arbitrations both at domestic and international fronts. The arbitration center of the High Court is established in furtherance of the Act of 1996, inaugurated on 14th April 2013 at the august hands of Honorable Mr. Justice Altamas Kabir, the then Chief Justice of India. Honorable Mr. Justice D.H. Waghela was the Chief Justice of the High Court at that time. The center facilitates voluntary and court-annexed arbitration. It has 9 court halls which has centralized air-conditioned system. It is spread over 9,656 square feet of area and provides the facilities including video conferencing to the stakeholders to connect the globe. The center has also digitalized facility and has panel of 149 arbitrators which consist of eminent former judges of the Supreme Court of India, of various high courts and the retired judicial officers. 31 arbitrators are from the field of engineering, information technology, trademarks, patents, town planning and other diverse fields. As Sister Justice Mudgal said, at present, more than 1200 cases are pending, which are only 28 at the inception. The graph, the upward graph, reflects efficiency of the center as well as the popularity to which the arbitration has reached among the class of litigants. In any world-class modern arbitration center, one may visualize the digitalized and paperless working, application of new websites and softwares, spacious premises with world-class amenities for the arbitrators and litigants, online services, and all upgraded infrastructure. But when we talk of creating world-class arbitral institutions, which is the theme of this week, the focus has to transcend beyond the availability of infrastructural facilities, rather beyond physical infrastructural facilities. Although these are the indispensable requirements, the institution of arbitral process as alternative dispute resolution system can be better built if the arbitration is achieved as convenient, cost-effective, and as a method committed to bring out speedy solution to the disputes between the parties. It is a time while building the healthy arbitration to ensure that this mechanism does not remain confined to the business or commercial class, or does not remain a elite system of resolution dispute, but it caters the need to all the classes of litigants. The arbitration process for this purpose has to be transparent, dependable, economical, honest. It has to reform itself as litigant service process. Even the smaller and relatively poor class of the litigants should have recourse to the arbitration processes. The system is capable of delivering speedy resolution, but it has to be done without sophistication and the high cost. The ADR week to be celebrated will churn out the recent issues to be addressed in the process and provide us a think tank for building better institution for the arbitration in the country and in the Karnataka. I wish the participants a productive ADR week. Thank you so much.
The ADR institutions and the institutional framework, and the need to embrace technology to achieve better dispensation of justice through arbitration process, and the need to respond by the system to the increased faith being reposed by the litigant in arbitration process, which in fact is reflected in the increasing number of arbitrations. We have seen that the number of arbitrations being now done in the Bangalore Arbitration Center has increased a lot, and there are more than 1,000 odd live cases which are being handled as on today. Thank you very much, sir. Now, I would request the committee members to come backstage. As a token of our appreciation for lending their support to the Bangalore Area Week, we would like to honor the dignitaries who have graciously accepted our invitation to be part of this event. First and foremost, we thank Justice Nagaratna for supporting this initiative of the Bangalore Bar. I request Justice Anu Shivaraman, Justice K.S. Mudgal, Justice Muhammad Nawaz, and Shri Uday Holla to join us in felicitating Justice Nagaratna. To Justice Arvind Kumar for taking time out from his busy schedule to be present with us today, and also for providing his inputs with regard to various aspects of the event. I request Honorable Srimati Justice Anu Shivaraman, Justice K.S. Mudgal, Justice Uma, and Sri Naganand to felicitate Justice Arvind Kumar. Thank you, sir. This N.K. Anjaria has been a steady pillar of strength and support throughout the preparation process for this event, and we are grateful for his unwavered support in ensuring that the event is a grand success. May I request Justice Anu Shivaraman, Justice K.S. Mudgal, Justice C.M. Punacha, and Mr. Gaurav Banerjee to kindly join us in felicitating Justice Anjaria. We are also grateful to Justice Anu Sivaraman for her generosity in hosting Bangalore ADR Week at the Karnataka Judicial Academy. We could not have asked for a better venue to host this maiden edition of Bangalore ADR Week, and I would request Justice Mudgal, Justice Uma, and Justice C.M. Punacha and Dhyan Chinappa to kindly join us in felicitating Justice Anu Shivaraman. Justice Mudgal's steadfast spirit and commitment for making Bangalore ADR Week a grand success. From the day we presented the idea of Bangalore ADR Week as a mere concept, Justice Mudgal has been a pillar of support to all of us, and she's been with the organizing team, supervising every aspect of the event. And I would now request Justice Mohammad Nawaz, Justice M.G. Uma and Justice C.M. Punacha and Harish Narasappa to join us in felicitating Justice Mudgal. Has taken time out to be here today amongst us, and he has also offered his practical insight into the constitution of arbitral tribunal and issues of conflict and how to deal with them during the classroom sessions that we had held for the young advocates, which started this morning as a prelude to the Bangalore ADR week. I request Srimati Manisha Kongovi, Srimati Lakshmi Menon, and Mrinal Shankar to felicitate Mr. Arvind Kamath. We thank our inaugural message and assurances given to us. We are also grateful for your support, continued support that you have given us for the success of Bangalore ADR week. I request Srimati Tamara Sakweria, Mr. Pradeep Naik, and Mr. Prashant to join us in felicitating Mr. Shetty. We are also grateful to Mr. Vivek Subbareddy for his support in organizing this Bangalore ADR week. And there is always a constant endeavor on his part to support all initiatives by the Bangalore bar for any event that is held by the bar. I request Mr. Dinesh Hegde, Director, Arbitration and Conciliation Center, Mrs. Pinaz Mehta, and Mrinal Shankar to join us in felicitating Mr. Vivek Reddy. May I now request Justice Arvind Kumar, Judge Supreme Court of India, to deliver the keynote address.
dignitaries on the dais, my esteemed sister, Justice B.V. Nagaratna, Judge Supreme Court of India, Justice Nilesh V. Anjaria, Chief Justice, High Court of Karnataka, Honorable Justice R.V. Ravindran, former Judge, Supreme Court of India, Justice Anu Sivaraman, Judge, High Court of Karnataka and President, Karnataka Judicial Academy, Srimati Justice K.S. Mudgal, Judge, High Court of Karnataka and President, Arbitration and Conciliation Center, Bengaluru, Sriranga, Learned Senior Advocate, Mr. Shashikiran Shetty, Learned Advocate General, Mr. Arvind Kamath, Learned Additional Solicitor General of India, Mr. Vivek Subbareddy, President, Vibrant President of Advocates Association, Bengaluru, Honorable dignitaries of the dais, my esteemed brother and sister judges of High Court of Karnataka, former judges of High Court of Karnataka, Registrar General and Registrars of High Court of Karnataka, directors and all officers of the Karnataka Judicial Academy and Arbitration Center, learned judicial officers, learned senior advocates, office bearers of Advocates Association, Bengaluru, learned members of the bar, friends from print and electronic media, ladies and gentlemen. It's a great privilege to be here today to deliver this keynote address at ADR Week, Bengaluru. I express my deepest gratitude to the organizers for inviting me to speak on a crucial subject or the topic, the theme of the conference being expanding the horizons and marching towards a world-class arbitration institution, which is both timely and significant. Arbitration and access to justice are inextricably connected to each other. Not just the Supreme Court articulated the idea that access to justice is a fundamental right. In Ketana of Judgments, to quote a few, Tamil Nadu Mercantile Bank reported in 2009 to ACC, Krishnakant Tamrakar versus State of Madhya Pradesh, 2018-17 ACC, page 27, Roger Matthew versus South India Bank Limited, 2020, 6 ACC 1, among other judgments. It also finds a place, this concept of justice, access to justice also finds a place in our preamble of the Constitution and also in the directive principles of state policy. Arbitration as a process of justice delivery is substitutional in character, that is to say, the existence of an arbitration clause in a contract, deed or regulation bars access to traditional forms of justice delivery. If there is a consistent policy to promote arbitration by legislature, executive, and such policy is also reiterated by judicial pronouncements, it is a constitutional duty and obligation of all the three organs of the state to ensure its implementation. While the traditional forms of justice delivery are displaced, arbitration proves to be a worthy or an equivalent substitute. In other words, if arbitration does not prove to be an effective remedy, then substitution of traditional courts results in deprivation of access to justice to those sections of the society who are disadvantaged and do not have the means to fight for justice on multiple fronts. The effectiveness of remedy must be measured at least on 5 parameters which are non-exhaustive. 1. Certainty of forum and procedure. 2. Impartiality of the forum. 3. Cohesiveness of the remedy, that is, avoid fragmentation of remedy. 4. Affordability of the remedy. And 5th, reasonable time of resolution. And I will dwell upon these aspects a little later by giving a bird's eye view. Today's keynote address will be a journey through the evolution of arbitration in India, guided by the present theme of the conference. I will start by examining the historical background, the current dominance of ad hoc arbitration over institutional framework, identifying key challenges such as awareness gaps, judicial interference, infrastructure limitations, and cost perceptions. Drawing insights from global leaders like Singapore International Arbitration Center, which I refer to as SICA, and London Court of Arbitration, International Arbitration, that is LCIA, I will analyze their successful attributes: autonomy, efficiency, expertise, accessibility, and cost effectiveness. We will then delve upon the barriers hindering India's arbitration growth, including legal complexities, cultural preferences, perception issues, and international competition. Finally, I will outline a strategic roadmap to establish Bangalore as a global arbitration hub. This includes initiatives like legal forums, infrastructure development, capacity building, awareness campaigns, and international partnerships. Together, I hope that we would explore how India can achieve its potential as a leading player in international arbitration. The historical background has already been stated by many speakers. Without delving upon the details, I would like to highlight that the breaking legislation empowered court to refer certain cases to arbitration, provided both parties consented by the Bengal Regulation Act 1972. Subsequently, the Arbitration Act was enacted, albeit with a limited scope, as it applied exclusively to presidency towns of Calcutta, Bombay, and Madras. A true watershed moment in Indian arbitration history came with the introduction of Arbitration Act 1940, which was a comprehensive legislation modeled after the English Act 1934, and it served as a cornerstone of domestic arbitration for over 5 decades. It is worth noting that this act represented a significant leap forward in standardizing the arbitration procedures across the country. Subsequently, to cater to the growing need of international arbitration, 2 additional acts were introduced. First, the Arbitration Protocol and Convention Act of 1937, followed by Foreign Awards Recognition and Enforcement Act of 1961, which legislations were specifically designed to deal with foreign awards, thereby ensuring India's presence in the global landscape. And landmark piece of legislation that sought to revolutionize our arbitration was introduced through Arbitration and Conciliation Act 1996, which drew inspiration from UNICITRAL model, which was designed with 2 primary objectives, namely, 1, to modernize India's arbitration system, 2, to align with international standards. In doing so, it effectively consolidated previous statutes and encompassed both domestic and international commercial arbitration by a single comprehensive law. This act was not without criticism, despite the advantages it produced. On the recommendations of 246th Law Commission's report, significant amendments were introduced in 2015 with the express purpose of enhancing the efficiency of arbitration proceedings and curtailing unnecessary court intervention. In our commitment to refining India's arbitration landscape, additional amendments were implemented in 2019 and 21, which underscored our nation's dedication in continuously improving and adopting our arbitration laws to meet the evolving needs of the legal and business communities. Arbitration has been recognized as an effective means of resolving disputes, particularly in the business world. It offers a level of efficiency, expertise, and confidentiality that traditional court systems often struggle to provide. Yet, despite its potential, arbitration in India has not fully realized its promise. The major issue plaguing our arbitration regime is its ad hocism. In India, effectiveness of judicial remedy must not be viewed from the perspective of affluent alone. Also have to wait the longest access to justice. In cases involving small claims, where there is an arbitration clause but not named arbitrator or an institution, the process of securing a forum for dispute resolution and the procedure to be followed itself becomes onerous, even before the actual dispute can be resolved. In a considerable number of cases, courts exercise power under Section 8 of the Arbitration and Conciliation Act to appoint arbitrators, and in such cases, invariably the process adopted is an ad hoc one. There is no certainty of either the forum or the procedure or the person who is said to be appointed. In such circumstances, most of the parameters of an effective judicial remedy, as mentioned above, were not satisfied, since ad hocism is the rule and certainty is disdained. I would confine my address to 4 issues. 1. Current state of arbitral institutions in India. Comparative analysis of Singapore International Arbitration Center, London Court of International Arbitration, and other leading institutions. Third one was to why India has lagged behind as an arbitration destination. And what are the steps we may have to take for building a world-class arbitration center in Bangalore? And ultimately, the conclusion which I would like to draw. On the first aspect, that is the current state of arbitration institutions in India, this can be subclassified as institutional versus ad hoc arbitration. Present scenario, challenges faced, lack of awareness and trust, judicial intervention, infrastructure and resources, cost and delays are some of the factors. To begin, let us understand the distinction between institutional arbitration and ad hoc arbitration. Institutional arbitration is conducted under the rules and administration of an established arbitrational institution. These institutions provide structured framework, administrative support, a panel of qualified arbitrators like Singapore Arbitration Center and the London Court of International Arbitration. An ad hoc arbitration, on the other hand, is organized independently by the parties involved. While the ad hoc arbitration offers flexibility and potential cost savings, it often lacks the consistency and predictability of institutional arbitrations. In India, ad hoc arbitration remains the predominant choice. This preference can be attributed to several factors. Firstly, there is a general lack of awareness and trust in institution managements. Many businesses and legal professions are not fully aware of its benefits, leading to preference for more familiar and ad hoc approach. Ad hocism in arbitration results in exclusionary access to justice. Without a regulatory framework tempered by constitutional principles, the right to access to justice is rendered exclusionary either in terms of financial capacity, geographical location, that is access to arbitral institution, or unequal bargaining power. Even if we look at it from the context of institutional arbitration, almost all arbitration institutions are located in metropolitan or cosmopolitan cities. However, the fact of the matter is that most of the disputes which can be referred to and resolved by way of arbitration can be traced in Tier 2 and Tier 3 cities and towns. In fact, pendency of the cases are also high in such places for the simple reason that about 70% of India's population reside in such cities, towns and villages. The need of the hour is to have arbitrary institutions even in such places. If that is not a feasible idea, then perhaps we can have a panel of arbitrators in each district and taluka from which appointments are made. This will give credibility and certainty to arbitration as a mode of dispute resolution. Long and short, we need to focus on decentralization of the system. We need to take positive steps, developing such a robust system which can cater to the people across the strata. Accessibility has yet another angle. As mentioned here in above, a majority of the cases are pending in our trial courts. These includes a wide variety of cases such as money recovery suits, agricultural farming disputes, property or land disputes, licensing disputes, and the like. These cases usually end up taking considerable amount of time, money and energy of the litigants when tried to be resolved through court litigation. It is these kinds of disputes that arbitration can play a huge role in reducing backlog and speeding up their resolution. Right now, such disputes do not get access to arbitration or other forms of alternative substitutional modes of dispute resolution. There is no gainsaying that the biggest challenge confronting us is the pendency of the cases. The number of cases pending disposal are phenomenal, and if we do not address this issue, the faith reposed by the common man in our system will slowly start eroding. The adversarial system of litigation has not helped us as it is time consuming, unpredictable, inefficient, and coercive. Thus, there is a time has come where we have to incorporate substitutional modes of disputes resolution in our dispute resolution process. More importantly, we need to make it an effective and efficient substitute to litigation. Arbitration allows parties to liberate themselves from technical nuances and coercive processes. Parties can also effectively use arbitration to reorient their relationship towards each other, as they can come together at the very outset, discuss the issues which can be amicably settled, the end being reducing dependency and ensuring speedy and efficient resolution of disputes. Yet another factor which requires deliberation at this ADR week is the arbitrator's fee, which is again an issue which is bothering the arbitral fraternity. Apart from the High Court of Bombay, High Court of Rajasthan, and High Court of Kerala, none of the other high courts have exercised their powers under Section 1114 of the Act as introduced by 2015 amendment to the Act to formulate rules for regulating fee to be paid to an arbitral tribunal. Even though Section 1114 has been replaced by 2019 amendment, but the same has not been brought into force. As such, there is a regulatory vacuum insofar as fees are concerned, which coupled with ad hocism that is prevalent in the appointment of arbitrators makes access to justice onerous. Even where rules have been framed, for example, Bombay High Court Rules 2018, they are restricted to appointments only made by the High Court and not to appointments made under Section 8. There may be a thinking by some of the members present here that in Karnataka that these rules are prevalent. I can say with candid confession, it is restricted to only to the institutional arbitration, that is Bangalore Arbitration Center, and that rule which has been framed for regulating the fee is not applicable to ad hoc arbitration. The enactment of rules or regulation constituting International Arbitration Center under the auspices of different high courts or independent arbitral institutions such as Mumbai Center for International Arbitration Center provides no relief to the ordinary citizens who for various reasons are unable to access these institutions. The Apex Court in ONGC versus AFCONS reported in 2024 4 SCC 481 emphasized that insofar as fixation of fee of the arbitration which go in ad hoc arbitrations. However, the decision makes way for a floodgate of litigation as courts retain the right to interfere in the order passed by the arbitrators fixing it or their fees as illustrated in section C 2.4 of the said decision. The another aspect is the lack of cohesive element of an effective judicial remedy is also lost because one has to institute multiple judicial remedies to get an arbitrator appointed, take out proceedings for sorting out procedural issues, motions have to be filed for issues arising out of arbitrator fees, and finally perhaps the dispute will be adjudicated on merits. This renders the effectiveness of the remedy completely illusionary because the remedies are then fragmented across fora. Yet again, this issue is something which the parties will encounter with institutional as well as non-institutional arbitration. It must be borne in mind that the state under Article 39A of the Constitution is obliged to secure the operation of the legal system that promotes justice on the basis of equal opportunity and to ensure that opportunities for securing justice are not denied to any citizen. Judicial intervention is another significant challenge. Indian courts have a history of interfering in arbitration proceedings, which undermines the autonomy and efficiency of the processes. While recent legal reforms aim to address this issue, the perception of excessive court involvement still persists. Infrastructure and resources also play a crucial role. Many Indian arbitral institutions lack the necessary facilities, technology, and support services to operate effectively. This inadequacy affects their ability to manage cases effectively and deliver quality outcomes. Finally, there is a perception that institutional arbitration is more expensive and time consuming than ad hoc arbitration. This perception, whether accurate or not, deters parties from choosing institutional routes. And this aspect also is a food for thought in the coming days to be deliberated upon by the speakers. Another aspect which I would like to delve is this comparative analysis. That is the Singapore and the London Court of Arbitration. The key attributes are autonomy and efficiency, professionalism and expertise, accessibility and user support, and cost effectiveness. To chart a path forward, it is helpful to look at the success stories of these leading arbitral institutions. This Singapore Arbitration Center is widely regarded as one of the most efficient and effective arbitral institutions globally. Its success can be attributed to several factors. Firstly, it operates with a high degree of autonomy and efficiency. It has established a reputation for delivering quick and reliable outcomes, which is a significant draw for international parties. The enforceability of SICA awards is another key factor, namely, it is enforceable in numerous jurisdictions around the world, providing parties with confidence in the arbitration process. The London Court of Arbitration is another exemplary institution for its expertise and robust set of rules which provide clarity and predictability to the arbitration process is another factor which makes the parties to choose the said center as an arbitration. It also employs highly qualified arbitrators and administrators, ensuring the parties receive the best professional and competent service. Both these institutions share several key attributes and contribute to their success. They operate independently with minimal court interference. They employ professional and experienced staff, ensuring high quality administration. They offer comprehensive support services, making arbitration process user friendly. The question which would require our deliberation is as to why India has lagged behind as an arbitration destination. This can be subclassified as legal and regulatory framework, cultural and structural barriers, perception issues, and competition from established centers. Firstly, our legal and regulatory framework needs significant reform. While recent amendments to the Arbitration and Conciliation Act aim to reduce judicial intervention, it needs more to be done to ensure that courts supports rather than hinder the arbitration processes. Cultural and structural barriers also play a role. There is a deep-rooted preference for ad hoc arbitration and litigation in India. These methods are seen as more familiar and in some cases more controllable. Perception issues cannot be overlooked either. Concerns about the neutrality, quality, efficiency of Indian arbitral institutions have deterred international parties from choosing India as their arbitration venue. Finally, the competition from established arbitration centers like Singapore, London, and Hong Kong is fierce. These centers have built strong reputation over the years and making it difficult for new entrants to compete. And to make the Bangalore as a world-class arbitration center, we have to take steps with reference to tailored solutions, key initiatives, legal reforms, institutional strengthening, capacity building, awareness campaigns, and international collaborations. So the question would be, how can we transform Bangalore into a world-class arbitration center? It starts with a clear vision and a strategic roadmap. We must learn from the best practices of the global leaders, but tailor our solutions to address the specific challenges within the Indian context. Key initiative will be crucial in this reformation. Firstly, legal reforms are needed to streamline regulations and reduce judicial intervention. This will help build trust and confidence in the arbitration processes. Strengthening our infrastructure is also essential. This means building state-of-the-art facilities, ensuring professional management, and providing comprehensive support services. We must invest in technology and resources to create a modern and efficient arbitration environment. Capacity building is another critical area. We need to invest in training arbitrators and legal professionals to enhance their skills and knowledge. This will help build a pool of qualified and experienced professionals who can deliver high quality arbitration services. I hope and trust that the Karnataka Judicial Academy would take this idea or concept to a higher level and train advocates also to be professional arbitrators. Lastly, international collaborations will be vital. Partnering with established global institutions can facilitate knowledge exchange and provide valuable insights into best practices. These partnerships can help build credibility and attract international parties to choose Bangalore as their arbitration venue. To conclude, our nation features in the top 5 economies of the world. With booming trade and commerce, disputes are bound to arise. The question which arises is whether we are in a position to provide for a speedy, effective, and affordable dispute resolution mechanism. Arbitration is one such mechanism. How to make it viable so in substitute the above stated creases can be ironed out, and India has the potential to become a hub of international arbitration. The question is what is stopping us from is our own dispositions and complexities which have created towards this method of dispute resolution. Transforming India into an arbitration hub is a collective effort. It requires commitment and collaboration of legal professionals, policymakers, and businesses. By addressing the challenges and leveraging the strengths of the institutional arbitration, we can create a more efficient, reliable, and globally competitive arbitration environment. I am optimistic about India's potential to emerge as a global arbitration hub. With the right vision, strategy, and determination, we can resolve the existing trends and build a world-class arbitral institution in Bangalore. Before I conclude, I would like to state Mr. Vivek Subbareddy made a mention that there is an arbitration institution has to be established for which the state has to give 100 acres of land. He will be failing in his duty if he doesn't make this demand as the president of the bar. But I can tell with all humility at my command that when I was in Karnataka and when Justice Abhay Srinivas Oak was the Chief Justice, during COVID period, we went to 5 places to select a site for arbitration center. Before that, I would like to mention one aspect, that is we should recollect with pride that the Bangalore International Arbitration Center has been opened because of the vision of Honorable Justice Vikramjit Sen. I say so because one day when I was sitting with him, along with him in the bench, he said, "Brother, this weekend you are going to Delhi." I said, "Sir, Chief, why should I go to Delhi?" He said, "There is an arbitration center in Delhi. You please go and visit. We will establish one arbitration center in Bangalore." I said, "Chief, I am the last batsman. I was the 37th judge. So if you send me, many eyes may become red. So you think of evolving something better plan." Then he said, "All right, I will make 2 other senior judges to come with you." So I went with the 2 senior judges. We had a first-hand information and we prepared a small note of 8 pages and gave it to Justice Vikramjit Sen. The next person which we will have to remember is Mr. S.V. Rangnath, the then Chief Secretary. He was called and he said, when the proposal was put, he immediately said, "Sir, I will work out with the government and come out with a proposal." The chief said, "We do not want any small area. We want minimum 10,000 square feet." And that is how in Khanija Bhavana, the first arbitration center was opened, and later on another about 8,000 square feet was given, and this is where the present arbitration center is working. Now going back to what we did during COVID period, we visited 5 sites and finally zeroed down to one particular site which measured 3 acres 2 guntas, for which allotment was done by the then government of Karnataka. So it is for the learned Advocate General to take it forward, and this would also meet the demand of Mr. Vivek Subbareddy, because there was a plan prepared to have a international arbitration center. And the last aspect, when I heard about this ADR week being conducted, I also heard from some quarters saying that there should be a separate arbitrators practicing on arbitration, advocates bar. My humble request, my appeal to the learned members of the bar, please don't break the bar. Let there be one bar. It should speak with one voice. There should be one bar association. So with this, I thank you for your kind attention, and I look forward for the fruitful discussion that will take place during the ADR week. Together, let's expand the horizons and march towards a brighter future for arbitration in India. Jai Hind, Jai Karnataka.
Thank you, sir, for your thought-provoking remarks and the guidance that you have given for the way forward. You have analyzed the law and how it has fared over the years in India, and the comparison between the downside of ad hoc arbitration versus the advantages of the institutional arbitration, need to formulate rules under Section 1114 under the Act. Of course, we are now governed by Schedule 4, which is now being followed by all ad hoc arbitrations. The excessive involvement of court in these matters, the comparison of institutions like SIAC, and what is it that is driving those institutions to become so successful, whereas institutions in India are lagging behind. And we are also having a session separately on the use of technology in arbitration. You have mentioned about a separate bar being created so far as arbitration is concerned. I think Mr. Gaurav Banerjee is here. He heads the arbitration bar, which operates from Delhi. Thank you very much for your remarks. Now, may I call upon Srimati Justice Nagaratna, Judge, Supreme Court of India, to deliver the inaugural address.
Namaskar and a very good evening to everybody. My esteemed brother, Justice Arvind Kumar, Honorable Judge, Supreme Court of India, Sri N.V. Anjaria, Chief Justice of the High Court of Karnataka, and Patron-in-Chief of this Academy and the Arbitration and Conciliation Center, Bengaluru, Justice Ravindran, former Supreme Court Judge and an ace arbitrator, Sister Justice Anu Shivaraman, Judge, High Court of Karnataka and President, Karnataka Judicial Academy, Sister Justice K.S. Mudgal of the High Court of Karnataka and President of the Arbitration and Conciliation Center, Bengaluru, my esteemed brother and sister judges of the High Court of Karnataka, learned arbitrators who are present here today, Shri K. Shashi Kiran Shetty, Advocate General for the State of Karnataka, Shri Arvind Kamath, Additional Solicitor General of India, High Court of Karnataka, Shri Vivek Subbareddy, President, Advocates Association, learned judicial officers, learned senior advocates and members of the bar, learned resource persons, directors of the Arbitration Center and Judicial Academy, Registrar General, High Court of Karnataka and registrars, distinguished invitees, members of the media, ladies and gentlemen. It is indeed an honor for me to deliver this inaugural address at the Bengaluru ADR Week 2024. I congratulate the Arbitration and Conciliation Center, Bengaluru, Karnataka Judicial Academy, Advocates Association, Bengaluru, and Bengaluru ADR Week Committee for their vision in promoting an incisive and practical discourse on India's arbitration landscape. The wide array of scheduled panels, from strengthening of ecosystems of arbitration to searching ADR mechanisms beyond arbitration, speak of an acute identification of what ails arbitration in India. A conference such as this should enable each one to be frank in one's views so that the most appropriate resolutions are passed and the plan of action emerge for the betterment of arbitration in India. I would preface my talk with the observation that the judicial fraternity world over is witnessing a new age of enlightenment in international arbitration. I say so because never before has such a diversity of controversies been left to the disposal of the arbitrators, and never before has so much autonomy been afforded to them. This is therefore an appropriate juncture for us to embark on a course of collective self-reflection, possible course correction, and perhaps even to plant the seeds of change so that arbitration as a mode of settlement of disputes continues to remain vibrant and continues to play a critical role in the global administration of commercial justice. The judicial tone that is being echoed around the world, including in England, Australia, New Zealand, Hong Kong, Singapore, and Korea, is that the role of the courts is to support and not to displace the arbitral process. Arbitration is said to provide parties with a certainty that the final award rendered at the end of the process will be recognized and enforced quickly. In a nutshell, the overall benefit one is expecting from arbitration is enforceability, flexibility, as well as time and cost efficiency. But there is a competing narrative which points to the other direction and which is relevant for our purpose today. Stakeholders often bemoan in writing and in conferences such as these the delays, inconsistencies, and inefficiencies that often plague arbitrations and related court proceedings. In the Indian context, arbitration is often considered to be the first step of a long stairway to obtaining justice. In short, arbitration is now increasingly being criticized as being neither time efficient nor cost saving. Thus, the debate on arbitration law reform is timely. Whilst, on the one hand, arbitration has now become the default choice for resolving private commercial disputes, there is also a rethinking of this utility in various quarters. For instance, the Ministry of Finance recent official memorandum recommends the use of arbitration in public works contracts only for disputes under rupees 10 crores and prefers mediation and court proceedings over arbitration for high value disputes under such contracts. And therefore, the bell is ringing now. While one can debate whether or not the criticisms of arbitration as a mode of dispute resolution are valid, clearly there is emergent dissatisfaction with arbitration processes and its ability to deliver on the promise of providing an expert, efficient, and effective dispute settlement option. What are these shortcomings, real and perceived, and how can they be addressed? I can only enumerate a few concerns as under: bias and impartiality concerns, procedural issues and transparency, enforcement challenges and limited recourse, judicial intervention and finality issue, due process and institutional standards, maintaining public trust in arbitration, concerns regarding forced arbitration, challenges in obtaining interim reliefs, excessive reliance on ad hoc arbitration, arbitrator expertise and the need for specialization, inadequate infrastructure and institutional support. I would like to be frank on some of these aspects today. Justice Ravindran, in his book Anomalies in Law and Justice, while speaking about Indian arbitration, has observed, and I quote, "It is rather depressing to see contracts which are to be performed in India entered in India by Indian entrepreneurs with other Indian entrepreneurs, providing that Indian law would be the substantive law governing the contract, but the seat of arbitration would be outside India, normally London or Singapore. Then why is arbitration outside India and not in India is a question which we must all think about. What ails arbitration in India? That arbitration is going away from India. Justice Ravindran has rightly identified 4 factors, namely delay, high cost, lack of professionalism, and excessive intervention by the courts. I may, as an example, just refer to the recent judgment of DMRC versus DAMEPL, where the Supreme Court used its curative jurisdiction to rectify what it thought was a flawed arbitral award, which underscored the delicate balance between maintaining finality and correcting gross miscarriages of justice. This case highlights that judicial oversight, although perceived to be potentially disruptive, is crucial for maintaining the integrity of arbitration, particularly when procedural lapses or biased conduct are evident. I will now touch upon certain roadblocks that ails the arbitration landscape in India and prevent arbitration from being the cost and time effective dispute resolution method it was originally intended to be. These roadblocks exist at the pre-appointment stage, during the arbitral proceedings, and during the challenge and execution of the arbitral award. I pray forgiveness if I am being frank to this enlightened audience. Parties are unable to agree on arbitrator appointments, which often result in approaching the High Court under 11(6) of the Arbitration and Conciliation Act to secure the constitution of the arbitral tribunal. There could also be delay on the part of the parties to commence arbitration in order to avoid recovery or court proceedings or to keep the dispute alive and undecided. There is need for all-round vigilance in order to curb such delays. Whether pre-arbitration steps such as mediation are conditions precedent to be satisfied before an arbitration can be commenced is still an area of some legal uncertainty. In my view, it should be crystallized as a norm in order to avoid a long drawn-out arbitration by addition of such a clause in the agreement itself. Now we moved from court proceedings to arbitration. Now it looks we have to find an alternative to arbitration. So now we think of mediation, and so we go on. Parties in arbitration proceedings often end up filing voluminous documents in support of their pleadings in an effort to inundate the counterparty with records to peruse and respond to. Such practices often lead to delays in the arbitration. In my experience, I have found that the most challenging is to draft a plaint. If you see the classic plaints of the early years, in old RFAs, you would see there will hardly be 5 pages. The entire substance of the case is stated and not one bit of evidence is stated in a plaint. But one has to epitomize all relevant facts, but at the same time not make it prolix by detailing evidence and irrelevant facts, possibly to impress clients, particularly corporates, and clients who value prolixity. Solicitors and advocates have taken to draft lengthy pleadings by losing sight of relevancy. Consequently, every letter and communication is adverted to, which makes the statement of claim and the documents voluminous. Moreover, unnecessary issues are raised and claims which cannot be granted are sought. As a result, pleadings lose focus on the actual dispute and concentrate on unnecessary and unwarranted issues which are countered in the written statement. A further rejoinder and surrejoinder only add to the pleadings to be transported in huge cartons, 3-wheeler autos, and trunks to the arbitration venue. My appeal to all law firms, lawyers engaged in arbitration, and other advisors is to draft the statement of claim in the form of a plaint, sans evidence and unnecessary reliefs being sought. It is a matter of common knowledge that voluminous pleadings lead to a number of issues on which evidence has to be led and arguments have to be made, which would inevitably drag on an arbitration. Also, unnecessary counterclaims are raised to match the claims, which may not arise at all, and they have to be countered by the claimant, which again make the pleadings voluminous. Many a time, escalation in the fee of the arbitrator is relatable to the huge claims made, whether justifiably or not. Look at the cascading effect. It all starts from the statement of claim. The tendency is to appoint what Justice Ravindran has very nicely termed high range arbitrators. And if there is a panel of 3 arbitrators, the fees would be trebled. Even a sole arbitrator can demand a high range of fees, having regard to the inflated claims and counterclaims made. Therefore, the responsibility lies with the parties as well as their lawyers to make reasonable and realistic claims in order to ensure that the cost of arbitration is reduced. Consequently, the delay in completion of the proceedings would automatically be reduced. Further, when the learned arbitrators eschew irrelevant pleadings and concentrate on the real issues and counterclaims and pass an award, advice is tendered to make an application under Section 34 of the Act to challenge denial of reliefs or claims which were not maintainable in the first place at all, and therefore the saga of arbitration is shifted to the district court and then in appeal to the High Court and thereafter to the Supreme Court. A system of settling facts, that is undisputed facts, will concretize what is actually to be proved in the arbitration. This will bring certainty to the factual dispute and evidence to be let in, and bring focus on the arguments to be advanced. Case management meetings, where parties can agree upon specific timelines and action points, has the potential to save both time and costs for parties, which is not adopted frequently in Indian arbitration proceedings. Although India is probably the only country in the world where there are statutory timelines to complete an arbitration, the timelines often have to be judicially extended for various reasons, rendering the timelines being directory and not mandatory. What would be the result if the court does not extend the timeline? In my view, extension of timelines cannot be taken for granted and assumed to be a normal exercise of jurisdiction. Then the challenge in enforcement. The enforcement of arbitral awards in India remains fraught with delays and legal challenges, albeit there being narrow grounds on which awards could be challenged. An increased use of Section 34, subsection 4, allowing the tribunal to make modifications where necessary, can be beneficial in effectuating the required changes. If effectively implemented, this could contribute towards a more robust arbitration result. Unlike courts of law, party autonomy enables the disputants to choose their arbitrators, but a party appointing an arbitrator to arbitrate the dispute cannot result in the arbitrator having any favorable disposition towards that party. Just as judges in courts of law are bound by rigor and discipline of adjudication of a case, the same rigor and discipline would apply to the arbitrator in arbitration proceedings. Retired judges, experienced advocates, and subject experts with professional expertise discharge their duties as arbitrators. However, dissatisfaction against arbitrators is a matter of concern, not only for the parties, but also for the entire system of arbitrators. Arbitrators must necessarily maintain high ethical standards of impartiality, and their integrity and independence can ensure the sanctity of awards, which would then not call for any court intervention. If any party complains about fantastic awards being given by the arbitrators, which is not in line with the settled principles of law, then naturally applications for setting aside such awards would pile up in courts. Such applications are argued by advocates as if they are regular first appeals. The grounds on which an arbitral award could be set aside must be borne in mind by the courts which deal with such applications for setting aside of arbitral award. In my view, even at this stage, there could be mediation of the dispute, since there is a crystallization of the claims and counterclaims in the form of an award, and if the parties ultimately arrive at a settlement before the mediator, the same could be recorded in the proceedings under Section 34 of the Act and the dispute being given a quietus. However, in most cases, the dispute travels from the district court to the High Court in the form of an appeal under Section 37 of the Act. The High Court must decide these appeals expeditiously and be conscious as to on what ground interference is called for, by bearing in mind the scope and ambit of Section 34 and 37 of the Act. It is also necessary at this stage for me to refer to some statistics regarding pendency of arbitration cases in the state of Karnataka, which would be more relevant for this conference. Recently, I think in 2022, Justice M.R. Shah and myself, we had the opportunity to pass directions to all the state high courts to ensure that the Section 11 applications are disposed of as early as possible so that there is commencement of arbitration. And we said the outer limit was 6 months. I hope those directions are being implemented in spirit, even though the timeline has lapsed long ago. In state of Karnataka, as on 31/7/2024, there were 2,413 pending arbitration cases in the district courts. Bangalore City has 425 arbitration applications out of 647 throughout the state, while in Ramanagara district, I think that is Bangalore Rural Court, it is 525 and 504 in Belagavi. The pendency of arbitration cases before the High Court as on 23/8/2024, that is yesterday, was 1,285 and 996 are before the principal bench. The pendency of arbitration applications under Section 11 of the Act before the High Court is 679. There are 235 miscellaneous first appeals before the division benches and 295 appeals before the single judge. Steps need to be taken for hearing and disposal of these cases by all stakeholders concerned. Some practical suggestions. Diversifying the pool of court-appointed arbitrators to include practitioners and sector-related experts has the potential to usher in far-reaching changes. In particular, prioritizing the appointment of women arbitrators will go a long way to address the criticism of arbitration being a male preserve and free it from its shackles of being what is called an elite, pale, male, and stale club. I must appeal to all the learned judges who sit on the CMP applications to please consider not only retired male judges, but retired female judges, women judges, district judges, and good advocates whom the judge thinks is competent. Please appoint them as arbitrators. Parties will also do well to embrace institutional arbitration and move away from ad hoc arbitration whilst drafting arbitration clauses. Making institutional arbitration the norm and ad hoc arbitration as an exception would go a long way in controlling arbitration proceedings, both in terms of cost and timelines. My learned brother, Justice Arvind Kumar, has spoken about this at length. Also, there is need for lawyers to dedicate themselves and gain expertise as arbitration counsel. In my view, arbitration cannot be limited to a weekend affair or to be held in the evenings after court hours. Arbitration proceedings must progress on a day-to-day basis once the pleadings are completed, issues are framed, and the recording of evidence commences. There can be no reason to stretch the period taken for recording of evidence. Witnesses must be examined on a day-to-day basis, and a time must be fixed for presentation of arguments, and written arguments could be the basis for oral arguments. Irrelevant case law and citations must be avoided, as this will result in focus being lost on an issue. Thus, case management must be followed for each arbitration by fixing the timelines in the very beginning of the arbitration proceedings when matters regarding fees and venue of arbitrations are discussed. The best way in most cases is to fix the timetable for the entirety of the arbitration at the very first hearing itself. While certain buffer periods can be built into such a timetable to cater to unexpected exigencies, India can emulate best practices worldwide where the hearing dates are considered to be sacrosanct and cannot be rescheduled except in extraordinary circumstances. This in turn infuses a greater amount of discipline and accountability to the process and can ensure that arbitrations are completed within the statutory timelines with no need for further extensions. It is essential that arbitrators award realistic costs to parties who succeed in the arbitration. This by itself will restrict disputants to raise only bona fide claims and defenses and preempt obstructive tactics in the arbitration process. Similarly, courts should do well to award realistic costs at Section 9, Section 34, and Section 37 stages, which will help preempt unmeritorious challenges to arbitral awards and induce a culture of voluntary compliance with arbitral decisions. Promoting the use of technology to reduce physical filings in arbitration and to conduct seamless virtual hearings in order to save administrative and travel costs would go a long way. The courts also have a crucial role to play in fostering an efficient ecosystem for arbitration. It is the supportive and supervisory jurisdiction of the courts and their ability to enforce arbitral awards that promotes arbitration and gives teeth to arbitral decisions in the ultimate analysis. While certain decisions can and should be debated threadbare, there can be no denying that it is the possibility of judicial review that maintain the parties and arbitrators' integrity and preserves the legitimacy of the dispute resolution process. Having dedicated courts for hearing arbitration cases, appointing of presiding officers or judges well versed in commercial matters, and more importantly, training of such presiding officers would go a long way in ensuring that procrastination of the matters is minimized and a decision is arrived at as expeditiously as possible. I'm happy that apart from sparing this hall, learned sister Justice Anu Shivaraman would also ensure in training of the judges, particularly commercial court judges and judges who deal with the arbitration matters. Further, the selection of arbitrators who lack subject matter expertise can compromise the quality of arbitral decisions. This often leads to challenges against awards, increasing the likelihood of judicial review. Enhancing the arbitration process by ensuring that arbitrators are selected based on relevant expertise can reduce the frequency of such challenges and hence the reliability of the arbitration progress. In this regard, I must clarify that the Arbitration Bar of India, which is sought to be set up by Mr. Gaurav Banerjee, Senior Advocate, is not to split the bar as such, but to make it more focused so that the arbitration bar can have a kind of a deliberation amongst themselves, and there could be certain members of the arbitration bar who are doing exclusively arbitration and not, shifting between the courts as well as the arbitrations. I hope he would not make it Delhi centric, for Delhi is not India and India is not Delhi, but make it truly an all India body. I'm sure the learned advocates here will help you to make it even to some extent Bangalore centric. While arbitration was sought as a beacon of hope for cost effective adjudication, experience reflects that this goal remains unattainable, mainly due to dilatory tactics. Although the arbitrator's fee is capped in institutional arbitration, such as those spearheaded by Bengaluru Arbitration Center, which is doing very good work, provided it gives better infrastructure to the arbitrators, to the advocates, in the form of secretarial assistance, providing more coffee and snacks and a place to sit and relax, because some of them may go, maybe not going back home, but taking up one arbitration in the morning and another one in the afternoon. The same is not the case in ad hoc arbitrations. As already noted, escalation in the fee of the arbitrator is relatable to the excessive and unjustifiable claims. responsibility lies with the parties as well as their lawyers to make reasonable and realistic claims in order to ensure that the cost of arbitration is reduced. Consequently, the delay in completion of the proceedings would automatically be reduced. In my view, one of the panacea to the extent to the what ails arbitration is to invoke an active ARB framework that actively invites the intervention by a panel of mediators or mediator once the pleadings are completed and the issues are framed by the arbitrators in order to explore the possibility of a settlement in the matter. In other words, arbitration proceedings could be paused for a few days or weeks once issues are framed by the arbitral tribunal for parties to realize as to where they stand in the dispute. At this stage, subject to confidentiality between the two proceedings, earnest efforts must be made for a final settlement before the mediators. Once a settlement terms are arrived at and signed, the matter could be taken up by the arbitrators who would only record the settlement and give a quietus to the dispute. Then there would be no Section 34, no Section 37, and no SLP. Experiences of Mr. Sam Kegel, the experienced mediator, who is credited for coining the term of Med-Arb, reflects that the benefit of a Med-Arb procedure is the transfer of authority to the mediator, as against the alternative would have been collective bargaining or crisis bargaining. As all sides are required to acknowledge that an obstinate outlook would subject them to subsequent binding decision making of the arbitrator, parties could be expected to experience responsible decision making. I hope arbitral institutions across the country will seek to adopt more dynamic and pragmatic policies for ARB, MED, ARB, and other like multi-tier dispute resolution mechanisms. I would suggest that the Bangalore Arbitration Center should empanel mediators who are, you see, commercially good, and they can be on the panel of mediation so that where the parties agree for mediation, the arbitration is paused and the matter goes before the mediator and possibly a dispute is resolved. Conclusion: if arbitration is really to succeed as an alternative dispute resolution in India, then, in my view, there must be a change in the mindset of the stakeholders, including the parties, advocates, lawyers, as well as the arbitrators themselves and the courts and judges who ultimately hear the challenge to such awards. One has to bear in mind the intentions with which the alternative dispute mechanism by way of arbitration was devised. Only such realization by all stakeholders could ensure success of the mechanism of arbitration, lest there would be a backlash against arbitration. The ultimate sufferers would be the parties, corporate confidence, investment environment, and ultimately the economy of the country. The goal of ease of doing business would remain an empty slogan without substance. A takeaway from this conference is to implement what is the resolve for the betterment of arbitration in the country. Whilst arbitration has its challenges, one would do well to not throw out the baby with the bathwater. Instead, changes in attitude and approach will go a long way in helping arbitration realize its promise. On this optimistic note, I thank the organizers for inviting me to this conference and to deliver the inaugural address and to share a few of my frank thoughts. I thank each one of you for your kind attention, for I am the last speaker, but I hope I was not the longest. Thank you and namaskar.
I thank Srimati Justice Nagaratna for her in-depth analysis of various issues and candid remarks. And as we now come to the last part of the inaugural session, we would be remiss if we do not thank all the people who have been instrumental in making the event a reality. I now request Mr. Harish Narasappa to deliver the vote of thanks.
So this event has been nearly a year in the making. I was scrolling my WhatsApp messages to see when we started discussing this. So Sriranga and I first exchanged messages around October last year about organizing such an event. And the first meeting happened on Jan 30th this year. So it's about 8 months that's been in the making. So there are a lot of people who have contributed to making this event a reality. So with permission of the dignitaries on the dais, I would like to follow a list of dates approach rather than follow the protocol. Apologies in advance. So first, Sriranga and I went and met Justice Mudgal and said we had this idea. She said, sounds good. Can you come back in 1 week with a concept note? We went back with a concept note only to realize that she was sitting there with a bunch of printouts of the Delhi Arbitration Weekend, the London Disputes Week, the Singapore Convention Week, and said, see, there are all these models that are already followed, so we should try and follow that. And she immediately took us to meet our chief, Justice Anjaria, who said, please go ahead. So we would like to thank our Chief Justice for encouraging us and giving us a free hand in organizing this event. Then we spoke to Justice Nagaratna. Justice Nagaratna said, do it in the Judicial Academy. Why do you want to spend money on 5-star hotels? If you want to bring all stakeholders together, it has to be a coming together of the bar and the bench. And she encouraged us to discuss the event with the Judicial Academy. So thank you, ma'am, for encouraging us and pointing us in the right direction. Then we went and met Justice Anu Shivraman, who had just been in Karnataka for a few weeks, but she welcomed us. I still remember the time we met her in her chambers, and she said, obviously, what's the question? Let's do it. And then both Justice Mudgal and Justice Shivraman again reconfirmed with our chief, who again said, go ahead, don't ask me again, give me the final program. Then we met Justice Arvind Kumar. I didn't meet him. I think Sriranga and Justice Mudgal spoke to him. And he said he not only agreed to come, he also gave us suggestions about adding 1 or 2 sessions, which we have added. I think he had suggested 3. I think we took the liberty of adding only 2. Thank you, sir, and apologies for missing out on the 3rd session. In between all this, Justice Mudgal said, listen, where is the bar involved all this? I don't see any of the office bearers of the Advocates Association here. So we said, no, we've already spoken to Vivek, and he said, Sriranga, Harish, you do whatever you want. We will be there for your support. Then we took Vivek to meet Justice Mudgal and the Advocates Association support. So we thank Vivek Reddy for basically telling us, please go ahead and treat this as an Advocates Association event. So thank you, Vivek. Shashikiran Shetty said, you tell me when to come and I'll be there. So thank you, Shashi. And Arvind, when I told him, Arvind, you may get only 5 minutes to speak, he said, I was not expecting to speak, I'll just be there. Please go ahead with the event. So thank you very much. And thank you for being a speaker at today's training session. I want to thank all the senior advocates who have made this event their own. We had 4 senior advocates who did the training sessions this all morning today. We have judges of the High Court, many senior advocates and senior members of the bar participating in the sessions over the next few days. But most importantly, the people who have toiled hard to make this event a reality. The ADR Week Organizing Committee, I know Sriranga and I have been here on behalf of the committee, but there are about 35 lawyers from about 12 law firms in Bangalore who have worked over the last 4 months to make this event a reality. Want to name some of them, Prashant Viji, Manisha Kangovi, Pradeep Nayak, Mrinal Shankar, Lakshmi Menon, Pinaz Mehta, and I know I'm missing some, Tamara Sequeira. So thank you all for leading the team of 35 people for the working over the last 4 weeks and proving that to make an event, an all-inclusive event, we need to bring together all the members involved in the ADR ecosystem, and that was our goal. I also want to thank the director of the Arbitration Center, Dinesh Hegde, and his 2 deputy directors, one of whom could not be here today because of some bereavement in the family, but they have been working hard, meeting with us almost every day. I want to thank Justice Marathe and his team at the KJA for facilitating the event. And I'm sure there'll be many people to thank over the next 2 days, which we will do in the valedictory session. So thank you very much, and we hope this event is a success and this becomes an event, an annual feature in Bangalore, so that we can bring the community together and pursue the ideas that the speakers on the dais have suggested in their speeches today. Thank you very much. Sorry, Sriranga has pointed out that thanks to Justice Mudgal and our chief, there is a significant presence of the honorable district judges who are going to participate in the sessions over the next few days. We thought they're an important stakeholder in the ADR system, particularly in Bangalore, because for those who are not from Bangalore, our 34 jurisdiction and our Section 9 applications go to the district judiciary. So we felt they're part of our ecosystem and we needed them to be part of this event, and Justice Mudgal and our chief have facilitated that. So we thank you, we thank all the judicial officers for attending this session over the next 3 days. Thank you.
We have now come to the end of the inaugural session. I would request everybody to rise for national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
Will be a Ganesh Stuti. It is a Marathi abhang which is sung by Shankar Mahadevan. It describes Sura Niraga Saho. Sura Niraga Saho meaning let the melody or the tune that is playing be pure and innocent. As I was choreographing it, I interpreted it as Ganesha, let the music that comes out of us as human beings, let it be pure and innocent. Presenting Ganesh Stuti.
निरागसहो गणपति सूरनिरागसहो सूरनिरागसहो गणपति सूरनिरागसहो शुभनयना करुणामय गौरीहर श्री वरद विनायक शुभनयना करुणामय गौरीहर श्री वरद विनायक ओंकार गणपति ओंकार गणपति अधिपति सुखपति छंदपति गंधपति लीन निरंतर हो लीन निरंतर हो सूरनिरागस हो सूरनिरागस हो गणपति सूर निरागस हो मोरया मोरया गणपति बाप्पा मोरया 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 गणपति बाप्पा मोरया गजवदना तू सुख करता गजवदना तू दुख हरता गजवदना मोरया 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 गणपति बाप्पा मोरया गजवदना तू सुख करता गजवदना तू दुख हरता गजवदना मोरया मोरया सूरनिरागस हो गणपति सूरनिरागस हो सुमनानी भरली ओंजळ नित्य रीती व्हावी चरणावर आन्हे बालक सुमधुर हासे भावत सेवा हो सुरातून ओंकार गणपति अधिपति सुखपति छंदपति गंधपति अधिपति सुखपति छंदपति गंधपति सुरपति लीन निरंतर हो लीन निरंतर हो सूरनिरागस हो सूरनिरागस हो गणपति सूरनिरागस हो मोरया मोरया गणपति बाप्पा मोरया 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 गणपति बाप्पा मोरया गजवदना तू सुख करता गजवदना तू दुख हरता गजवदना मोरया 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 गणपति बाप्पा मोरया गजवदना तू सुख करता गजवदना तू दुख हरता गजवदना मोरया सूरनिरागस हो सूरनिरागस हो
performance of this evening. I'll be presenting a Chaturang. Chaturang in Kathak means Charang. Sahitya, Tarana, Nritta and Sargam. So the Sahitya of this composition is very interesting. It is an argument between Gopika and Krishna. She says, why are you holding my hand? Why are you pulling my chunni? Why are you throwing stones on my matka and creating a mess? Look, everybody is looking at me and they're laughing. Huh? Are you still a small child? Look how big you've become. Teri aarti utar dungi main. Then she says, see, I'm married. Why can't you keep my promise? Don't do all this in front of people so that they laugh at me. Huh? You want me to fall to your feet? Why can't you stay the Gopalaka who loves to take care of his cows? Who lifted the Govardhan? Who danced on the Kalinga? Why do you have to do all these other things? Presenting Chaturang. This is a composition by my guru, Shama Bhate, in Ektal. Coming to our concluding performance for today will be a Tarana, which is in Rag Darbari. And the original composition is by Daga Brothers, which was further later worked on by Praveen D. Rao and my gurus Srimati Nirupama ma'am and Rajendra sir, presenting a Tarana in Rag Darbari. I'm really sorry you had to see that. I don't know. Today what happened, my gungru broke in the middle of the stage. This usually never happens. I'm sorry it had to happen here and you all had to witness this. I hope you all enjoyed the show, and I would like to thank Ranga sir for providing me this wonderful opportunity to perform in front of you all. Thank you so much. Shubharatri.